Welcome to Then and Now, a podcast by the UCLA Luskin Center for History and Policy. We study change in order to make change, linking knowledge of the past to the quest for a better future. Every other week, we examine the most pressing issues of the day through a historical lens, helping us understand what happened then and what that means for us now.
Welcome to Then and Now. I'm David Myers, your host, and today we will be speaking about abortion, the history of debates over it, present-day legal proceedings, and the future. We are recording this podcast several hours after the Supreme Court heard arguments in Dobbs v. Jackson Women's Health Organization, a case involving a Mississippi state law that bans abortion after 15 weeks of pregnancy. This would seem to be a rejection of the right to an abortion established in the court's landmark 1973 Roe v. Wade decision. Are we, in fact, on the brink of a decision by the Supreme Court to break its own precedent that established a constitutional right to abortion in Roe? If so, how sweeping will that change be? The stakes are enormously high for advocates on both sides. To help understand where we are and how we got here, I'm delighted to welcome to Then and Now Cary Franklin, who has joined the UCLA faculty this year as McDonald Wright Professor of Law and Faculty Director of the Williams Institute, which is devoted to studying sexual orientation and gender identity law and public policy. Professor Franklin is an expert on constitutional law, anti-discrimination law, and legal history, with a particular expertise on sex, sexual discrimination, gender identity, and race. Welcome to Then and Now, Professor Franklin.
Thank you so much. I'm glad to be here.
So let us jump right in. Abortion has been a source of contention and division throughout a good part of U.S. history, though, of course, the touchstone for current debates and controversies is the Supreme Court's decision in Roe v. Wade from 1973. This is a very tall order to ask of you, but could you give us a brief summary of the history of abortion in the United States and abortion law before Roe?
Yeah, so that is a tall order. I'm going to try to do 200 years in 2 minutes. That's my goal. Okay, so I will start in early America, say the time of the founding when the Constitution was written, the late 18th century. At that point, we had common law rules, and common law rules allowed abortion up until the point of quickening. That's when the woman said she could feel the fetus in utero. That could be up to 25 weeks. And up to that point, it was her decision to continue the pregnancy. In the second half of the 19th century, there was a campaign to tighten up abortion restrictions. This campaign had multiple motives, but many of them were unsavory and would be considered inappropriate today, namely eugenics. The idea was that Protestant women, especially married Protestant women, were getting abortions, and they were worried that Catholic and immigrant women were having a lot of children, and that would change the makeup of the population. There was also a worry about the women's suffrage movement and that women were breaking out of traditional roles. So a lot of anti-abortion advocates wanted to reinstill the notion that a traditional place for women in the home was the cornerstone of American society. And there were doctors who wanted to wrest control from male doctors who wanted to wrest control from midwives and get a monopoly over the performance of abortions. The result of this campaign was a series of criminal abortion laws in the late 19th century. Those stayed with us for several decades. But around the 1950s and 1960s, doctors began to complain about those laws because women were performing self-abortions. They were using coat hangers, they were using poisons, they were tumbling downstairs, they were asking people to pummel them in the stomach. Emergency rooms were full of people who performed self-abortions, and it was devastating. So doctors said, we need to reform these laws. So there was a campaign in the late 50s, 60s to do that. And in the late 60s, that campaign really took off. And in very quick succession, a dozen states passed therapeutic, more liberal abortion laws. This triggered a counter movement among the Catholic Church in particular to stop that liberalization of the abortion laws. So between 67 and 70, 12 states liberalized their abortion laws, but after 1970, none did, because although they were in the minority and the vast majority of Americans then as now support a right to abortion, the Catholic Church was more interested and more organized, and they stopped these liberalization laws in the state legislatures. So, as often happens in America, the issue ends up in court. 1973, the court hears Roe v. Wade, and that involves a Texas abortion law. That's the state of affairs when Roe gets to the court.
So just to drill down a little bit deeper, the late 60s, this period in which we begin to see liberalization, is a time of very powerful countercultural movements in the United States. It's a time when we begin to hear the first echoes of what will become the potent feminist movement. And it induces, both of those cultural moments induce their own conservative backlash. Is that set of cultural forces really the backdrop to this intensification of the debate over abortion? And if so, when do we begin to acquire the language, the very fraught language of abortion as murder, and by contrast, the idea of abortion as kind of inalienable right?
I'm really glad you asked that question. And I think if people take away one thing from this podcast, I hope it is this. It was very different. It was a very different landscape with very different ideologies and political alliances at the time of Roe than it was later. So you're absolutely right that the women's movement is beginning to form. And some people in the women's movement, some advocates in NOW, the National Organization of Women, are certainly supporting this doctor campaign. But I think it's important not to understate the degree to which it was really, at that point, a therapeutic medical effort to intervene to protect women's health and human rights. Although there were plenty of other movements and figures that were also involved. And as time progresses, the women's movement becomes increasingly important, but it already was involved in the 60s. But here's the thing that I want to say that's important. At the time of Roe, abortion simply was not that controversial. On the eve of the decision, there's a poll, more than 2/3 of Americans support it. After the decision comes down, more than 2/3 of Americans support it. The day Roe comes down, it's not even on the front page of the newspapers. In 1975, Justice John Paul Stevens is confirmed. No one even brings it up at his confirmation hearings, if you can believe that. Now it is the center of all judicial confirmation hearings. It is a huge controversy. In 1975, it wasn't even an issue. The famous pollster Lewis Harris said in 1975, Roe's just solidified the mainstream American support for abortion. It simply, I don't want to say there wasn't controversy over it, particularly the Catholic Church was involved, was engaged, was stopped those liberalizing laws, but it did not have the political valence it had today. It wasn't until the late 70s that more Republican legislators opposed abortion than Democratic legislators. It wasn't until the 1980s that more Republican voters opposed abortion than Democratic voters. And what happened in the mid to late 70s was a very concerted effort by Republican strategists to peel off Catholics from the Democratic Party and form a new coalition, a new moral majority that would unite evangelical Christians and Catholics for the first time. You are familiar with this if you remember that era or have studied it. The moral majority, Reagan, that whole movement uses abortion as a kind of wedge to try to get Catholics into the Republican Party. But you really don't see the Republican Party organizing around abortion until well after Roe. And you don't see the backlash until well after Roe. And you don't see what's familiar to us today until well after Roe. This is the thing I would like people to take away from the podcast. There is a deep-seated myth that is very hard to dislodge, that Roe inspired a huge backlash. No facts support that. That is a myth. Roe was used later, and it certainly was an effective tool, and it certainly has since been a fundraising tool and a divisive issue, and is very much at the center of party politics. But at the time, that's not the case.
Right. So Roe is 1973. The moral majority is established, I think, in 1979. Ronald Reagan is elected in 1980. We see the emergence of a very powerful new conservative Christian movement, for which abortion was one, but only one issue. I mean, school education was probably as important, if not more so. When do we see the language, the sort of very fraught moral and religious language of murder? Prominent Catholic officials refer to abortion as a spiritual holocaust. When do we see that intensification? Is that in the 80s and 90s? Is that the period that we basically see the incubation of the debate as we know it today, fraught as it is?
Yeah, it is. I mean, I want to say the Catholic Church, beginning before Roe, was opposed to abortion and had the view that it needed to be stopped. But this heightened, just megawatt debate that we're having, Operation Rescue, the shooting of abortion doctors, the picketing outside abortion clinics, the violence, the pictures of the bloody fetuses, all that's the 80s and 90s.
And how do we understand that?
Well, there have been excellent histories written about Paul Weyrich and other Republican strategists, Kevin Phillips, people who intentionally decided that this was a good issue to try to formulate this new political coalition. You're absolutely right that anti-school busing was actually one of the major issues, and abortion got aligned to that for strategic reasons about party realignment, and the set of political issues that are now familiar to us and that hang together really start to appear in the Republican Party platforms in the 1980s, but they're not hanging together, and those coalitions aren't yet together at the time of Roe. That is a later creation. I wrote an article once saying that Roe is a product of the 1980s. Roe as we know it, the 1980s are not a product of Roe. Roe is a product. Roe, at what we think when we think about Roe, that is created because of the conflict in the 80s and the 90s. And
the afterlife of Roe, or the reception of Roe.
Right.
Okay, let's go back to Roe itself. And can you just explain for us, what did Roe hold?
Okay, so Roe involves a law that criminalizes abortion. The only exception is for saving the life of the mother. This is challenged at the Supreme Court in 1973, and the court holds that there is a fundamental constitutional right to abortion. It holds that there's a right to privacy protected by the Constitution that we have recognized in other decisions, particularly those related to intimate family life, parents' decisions about when or if to have children and how to raise those children. There's a very important precedent in Griswold v. Connecticut that gave people married couples a constitutional right to use birth control. That was the most important precedent for Roe, but there were others enabling parents to teach their children in German or to send their children to Catholic schools, where this right of parental autonomy was recognized as a constitutional right. So Roe says abortion falls into that right to privacy umbrella. Now, just because something is a fundamental right doesn't mean the government can't infringe it. It just means the government has to have a very, very good reason for doing so. What's called in constitutional law a compelling interest. So here's what Roe says about how we're going to figure out when the cases come to us, when various laws come to us in the future. This is the test we're going to apply. The trimester framework. In the first trimester of a woman's pregnancy, the right is hers. She has a fundamental right to choose whether or not to have an abortion or carry the child. In the second trimester, the state's interest in protecting women's health becomes compelling. So they can pass regulations to protect women's health in the second trimester. In the third trimester, which begins in that era, that's the beginning of the start of viability, about week 28. At that point, Roe said, the state's interest in protecting fetal life becomes compelling, and so compelling that it overrides the woman's constitutional interest to abortion. So the state can regulate abortion in the third trimester up to and including banning it. And that is the doctrine that Roe lays out.
And I'm just curious, on what did it base that tripartite analysis? Was there existing case law upon which it rested, or was this the 9 justices or the 7 justices' own research and sort of new framework?
Well, there is a lengthy opening section in Roe that looks at history and tradition. It looks actually back to ancient times and then up through some of the early American history that I briefly alluded to about the protection up until quickening. And the trimester framework somewhat fits that analysis. The court saying, that's how we've always done it. We've always recognized early in a pregnancy, the woman has a right. Later in a pregnancy, the state's interests become more compelling. So now we're going to have to give a little bit of more shape and definition to that so that lower courts can apply that and doctors understand what the rules are. And that viability line is roughly like the quickening line. So we're going to say that 28-week mark is when the state can start regulating. But as you probably know, that trimester framework has come in for an enormous amount of criticism because obviously that's not written in the Constitution. That is a gloss on the Constitution that the judges themselves developed. I think Roe does a pretty good job of showing that it's rooted in past precedent and history, but you're absolutely right to suggest that that was vulnerable because they did concoct that. They didn't pull it from the text of the Constitution.
Right. And I want to go back to this point about the text of the Constitution and understand a little bit better the constitutionality of the right that is articulated in Roe. So there's a constitutional right to abortion that is rooted in the right to privacy, but the Constitution, as far as I know, doesn't mention privacy. So what's the logic chain that makes this a constitutional right as opposed to some other right?
So, yeah, and I should say, actually, I'm going to finish this answer by saying it has shifted the way we talk about. We don't talk about the right to privacy anymore. But at that time, because Griswold v. Connecticut relied on the right to privacy, Roe used that precedent and also relied on the right to privacy. And there was a question. Justices had different ideas about where you derive that idea. Most of them agreed that the Constitution protects privacy, but they had different notions of where you found that. So one idea is that constitutional rights, in order to enjoy our constitutional rights, there's a kind of space around those rights where we need to have some privacy. So you have a right to free speech. For instance, the court said in Griswold, you need to have a right to association as a kind of penumbral right or a right around the enumerated right. So the NAACP, for instance, needs to be able to have membership organization lists that the state can't get at to harass people. That's not in the Constitution, but it's implied if you're going to have a right to free speech that you also have to have some ancillary rights. Some justices argued, actually, we should ground this autonomy right in the text of the Constitution, in the 14th Amendment, which protects liberty. That's an enumerated right. The 14th Amendment protects liberty and equality. So even in Griswold, some justices believed that instead of privacy, that liberty would be the better place to root it. That is how we now root it and how we now talk about it. It has shifted from privacy to liberty, which is actually in the text of the Constitution. Privacy came under a lot of criticism, although I think there is a shared understanding that you do have certain privacy rights, right? The Third Amendment protects you against the state quartering troops in your house. The Fourth Amendment protects you from illegal searches and seizures. There are actually a lot of amendments you can cite that seem to have a notion of privacy embedded in them. But nonetheless, we've now moved over to liberty, which is actually listed in the Constitution as the foundation of the abortion right.
And do the opponents of Roe object to the notion that it is a constitutional right, or do they accept the idea that it's a constitutional right that needs to be overturned?
They reject the idea that it's a constitutional right. The difficulty, so one of the most important amendments in American history is the 14th Amendment. We passed it right after the Civil War, and it guaranteed liberty and equality. It's one of the most litigated and important parts of the Constitution. But what it says is you're protected against the state infringing your liberty and equality. Well, that's very broad, and it's not clear what that includes. And it's just inevitable that judges are going to have to do some judging. But the problem is, anytime they do some judging about what fits in that or doesn't, the other side is going to attack them and say, that's you imposing your own policy views. That's not in the text of the Constitution.
Okay, I want to understand a kind of confounding concept for me, which is the idea of precedent. What is the precedent for the Supreme Court overturning its own precedent? Is this a commonplace occurrence? Because there was an extended colloquy today, or series of colloquies today, involving the principle of stare decisis precedent, as if this were a very towering obstacle to overturning Roe, and yet it seems, in some sense, imminent. So, what's the history and what's the theory behind overturning precedent?
So, the Supreme Court in Marbury versus Madison declared that it had the final authority to say what the law is. So it has the right to say what the law is, including rejecting earlier statements about what the law is. However, there is a doctrine, a court-created doctrine, this is not in the Constitution, but it's a court-created doctrine called stare decisis. Stare decisis is a Latin phrase that means to stand by things decided. And what this means is when the court has decided an issue, we attach a lot of weight to that because we believe in rule of law values, because it is important to have consistency and to have predictability, because people have to know what the rules are. And it is important institutionally for the court not to appear like a political body, so that every time a new president comes in and appoints new justices, the court just swings, as if it is nothing other than politics, and the decisions could be erased at a moment's notice. The court does not believe in that and does not want that. It institutes stare decisis, which means we put a lot of weight on our precedent, and we're only going to overturn it if it satisfies a number of factors. I will just run through those factors. And this was a lot of today's argument. I should preface this by saying, when a majority of the court decides something, that becomes a precedent, and precedential weight attaches to that, and stare decisis starts to build. Now, Roe was decided in 1973. 50 years of stare decisis has built up around Roe. Overturning it would be quite a major undertaking. Here are the factors we consider in deciding whether it's legitimate to overturn a precedent. So one thing is we ask, was the original decision grievously or egregiously wrong? But that's not the only thing we add. That alone isn't enough to overturn a precedent, because stare decisis had a lot of weight to it. So it has to be grievously or egregiously wrong. We also look to see, have facts or law on the ground changed so that precedent is obsolete or doesn't make sense anymore? We ask whether it has proved workable. Have courts been able to implement the tests or the rules that got laid down? And then finally, we ask, has reliance built up on that decision? So has that become embedded in the fabric of society so that overturning it would rupture people's lives in a way that it was quite damaging? This came up a lot there was an important case about Miranda, right? When the police have to read you your rights. And there was an argument that there's nowhere in the Constitution that requires police to read you your rights. But one of the major arguments was, look at any TV show with police on it. Every American knows this. People rely on that they're going to get that warning when they're arrested. So we can't overturn that precedent because it just becomes something part of part of how we understand how the law works. So those are the factors we look to see whether you can overturn a precedent. It's supposed to be a rare thing that you do it, and it's supposed to be only if it satisfies all these factors.
Right. And just wondering, empirically or perhaps just anecdotally, is it the case that conservative judges or justices have been more hesitant to overturn precedent than liberal justices or judges? In other words, is this a conservative principle insofar as it's about conserving? Or would you say it's sort of universally held in the same regard?
Yes, you might think so, but no, I do not believe conservative justices are more enamored of stare decisis. And in fact, they may be less so. So the only justice who kind of openly disregards stare decisis is Clarence Thomas. And here's what he says. The meaning of the Constitution was set at the moment that the text was laid down. That is the meaning of the Constitution, and that is what I am obligated to enforce. So if previous courts got it wrong, I don't put a lot of stock in what they said. The Constitution is my lodestar. So that's what I'm going for. And I am obligated to correct past errors. And the final thing I'll just say is it's certainly not true now because the conservatives have the majority and they are whapping down precedents left and right because they are remaking the law as they see fit. And it's very much the liberal justices who are saying stare decisis, trying to protect what has come before.
It's hard to avoid the perception from a non-lawyer's viewpoint that law is politics, plain and simple. That all these beautiful principles, finely articulated, succumb to political sensibilities at the end of the day. Conservative justices are inclined to overturn Roe because it does not conform to their moral, religious, or political sensibilities. Should we resist that impulse to reduce law to politics?
I'll say two things. So first of all, there is a deep debate in the jurisprudential, legal, philosophical literature about whether there is law apart from politics. So people just disagree about that. I'll tell you my own view. I think when you're talking about especially constitutional law, of course it's politics. Of course it's deeply interwoven with politics. I think it's impossible to deny that, particularly given what I just said. The Constitution speaks in broad generalities like equality and liberty. That will inevitably, how you look at those phrases is going to be influenced by your political and cultural and moral understandings. That's inevitable. Here's where I don't think saying politics is interwoven with law is such a problem. I just think that's true and undeniable. I think the problem arises when we break down any legal norms. So the way I would understand law is not particularly different in substance than politics, but as a set of norms and practices. So here's a difference. Law is reason giving. The justices on the Supreme Court are required to explain fully why they're doing everything, to account for it, to cite precedent for it, and to explain it. Legislators don't need to do that. They can pass laws for whatever reason they want, for whatever personal predilections, and they don't need to explain themselves at all. Law is supposed to be cabined by prior decisions, by history, by judicial norms of behavior, comportment, and practice. And I think a lot of the frustration among my community, law professors right now, is it seems like that is breaking down. So the idea that law was a distinct set of practices and that judges were constrained in a way that politicians were not, that is what people fear is gone or quickly going away. And all sorts of bad consequences follow from that. So it's not that law is this special rarefied thing that isn't influenced by politics, but that many of us believe and think it is important that there's a practice of law that's different than a practice of politics. And right now, there doesn't seem to be a lot of evidence that there's a lot of constraint. And there's a fear that there's just a lot of Republican Party platform being implemented by judges. And if that's true, that's a real problem.
Would conservatives have said that about Brown v. Board or about the Warren Court?
Yes.
They would say the same thing. They're not constrained by sort of the vaunted
Every
principles and doctrines.
Every side that's out of power accuses the side in power of not having grounded in the Constitution, not doing law, just doing politics, just doing morality, just 5 justices unelected imposing their own will on the country. That, historians cite people from the 19th century saying that. People have always said that. I don't want to say, however, that it's just business as usual. However, I think there is something unusual going on right now.
What is that?
The degree to which the norms seem to be flagrantly disregarded is at a higher pitch. And, the American people know that. In the history of polling, the Supreme Court is now at its lowest level of approval rating that we've recorded. It's at a 40% approval rating. That's kind of like what legislators and presidents tend to get. The court was always way, way up because people trusted it. They believed it was independent. Even if they didn't agree with its decisions, they believed that there was a kind of reason-giving logical analysis going on. People don't believe that anymore. And that is a problem for the court. And I think you see this because the conservative justices are going to talk to the Federalist Society and giving big speeches saying, quote, Justice Amy Coney Barrett, we're not just a bunch of partisan hacks. The fact that she is going out there trying to give speeches saying she's not a partisan hack suggests the court is very worried about that perception.
Right. All right. Before we turn our attention to what transpired today, I want to just go back and review a number of important court decisions. So the first of them following Roe of great significance was Planned Parenthood v. Casey from 1992. Why was that important?
Yeah, and frankly, that's really, when people say Roe, what they actually sort of mean is Casey. Casey is the abortion precedent, the controlling abortion precedent for the last few decades. Casey replaced Roe. And Casey is what we're really talking about going away in Dobbs, today's case. So Casey substantially cut back the protections offered by Roe. It jettisoned the trimester framework. So we haven't actually used the trimester framework for decades. We used that in the 70s and 80s. It's gone. What Casey said was, Roe got it wrong because it said the state's interests only kick in later in a pregnancy. Actually, the state has an interest in protecting fetal life from the moment of conception. And the moment at which the state's interest outweighs the woman's right is viability. And there's just that line. So there's just one line. Post-viability, states can ban abortion. Pre-viability, states can regulate abortion. They can regulate abortion a lot more than Roe let them do. And the test now is going to be for pre-viable fetuses. So kind of before 24 weeks, the test is the state putting an undue burden on the woman's right? By which it means, is it putting a substantial obstacle in front of somebody trying to seek an abortion of an unviable fetus? That's abortion doctrine since 1992.
Okay. And more recently, we've had 2 state laws that made their way to the Supreme Court. One is the Texas law known as based on Senate Bill 8, and of course, today's case involving Dobbs v. Jackson. How do you understand these 2 cases and the backdrop to them, the political backdrop to them, and then what they did to Casey?
So there is no doubt that courts have become more sympathetic to abortion restrictions. And I would cite 2010 as a real turning point. 2010 midterm elections were extremely important. There was a sweep of very right-wing legislators into Congress, a lot of Tea Party folks, a lot of folks quite concerned about abortion and religious rights and liberties. And 2011 was the year on the books with the greatest number of abortion restrictions passed, because that new crop of legislators really made it their issue. So we saw an uptick until this year, which actually is overcame 2011. It is now the record-setting year for abortion laws in states. There are more than 100 abortion laws passed in states this year, many, 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 many hundreds proposed. It is the most restrictions, most laws we've seen since Roe. And partly what happened is what I talked about, the shift of the Republican Party to the right, the increasing influence of evangelical figures in that movement, but also, very importantly, Trump's election and his appointment of judges and justices, quite important to people kind of in the law world, is not just the Supreme Court justices. He appointed so many lower federal court judges, and that makes a huge difference. It'll be at least a generation, if not more, before we would move past where we are right now, because the federal courts are amazingly heavy with Trump appointees. But the lawmakers in the states were very openly saying, now we're going to try to pass these bans that are clearly unconstitutional under Roe and Casey, because did try a bit in the past and they just got overruled. They just got slapped down. Bans before 24 weeks, right? Pre-viability bans. That's not allowed under Casey. So that's unconstitutional. So occasionally a state would try it, and it didn't even get to the Supreme Court. The lower courts would get rid of it. But now they're saying, hey, let's try again. We've got a sympathetic court. And they were right. They were right. So Mississippi passed a 15-week ban. That is just clearly unconstitutional. There's not even any argument about that. Everyone would agree that's unconstitutional under Casey. That's unconstitutional under our law for 50 years. And there's no debate about that. The debate is whether our law is going to change or not. And the Texas law is a 6-week ban. Again, 100% unconstitutional, and there's no disagreement about that fact. But anti-abortion lawmakers have been emboldened because for the first time, they really feel like there's a great shot at getting rid of Roe and Casey.
The Texas bill had this unique and, in fact, quite radical feature to it, in which it set the burden of enforcement not on government actors, but rather on the general public and citizens. And is that the reason why it was beaten back by the Supreme Court so quickly?
Oh, it has not been beaten back yet. The Supreme Court extremely controversially let that law go into effect, and that law is in effect. And abortion is functionally banned in Texas right now, and has been for 2.5 months, and is an unbelievably dire situation in Texas right now. Generally what they do is stay a law until they can decide on the merits whether it's constitutional or not. They decided not to do that. They let that law go into effect, even though it's clearly a 6-week ban and unconstitutional. So that is very controversial that they did that. We're awaiting their decision any day. But I'll tell you, we're not even awaiting the decision on the merits of whether you can have a 6-week ban. What we're waiting for the decision on is whether Texas can evade constitutional review through this trick that they developed where you can't sue anybody. So they know, Texas lawmakers know that this is unconstitutional. They think they've developed a way that no one can challenge it by saying, normally when you challenge an abortion restriction, you sue the state officials charged with enforcing it. In fact, that's what you have to do. So Texas said, hey, we're not going to allow any state officials to enforce it. We're going to delegate to private individuals a right to get at least $10,000 anytime they hear of an abortion after 6 weeks, and no one can challenge it because you can't sue the individual under the Constitution. The Constitution constrains the state, not these individuals. So the problem with that is then there are no constitutional rights in this country, because you could just use that to get rid of gun rights, to get rid of religious liberties, to get rid of any right. You could just delegate to people the right to win civil lawsuits against anyone who has a gun or anyone who has an abortion, and no more Constitution.
Will the Supreme Court, to your mind, feel constrained by that possible state of anarchy that it could induce?
Yes, I do not think that ultimately that will succeed. I think the Supreme Court will close the loophole and will say you cannot skirt the Constitution through this trick. So I believe that Texas will lose the SB 8 case on the civil procedure question of whether you can sue someone. I think they will say you can sue someone, but I want to point out two things. One, they may very well in Dobbs hold that there's no fundamental right to abortion, at which point Texas may then just be allowed to pass a 6-week ban and have the state official enforce it, and it'll be constitutional because women don't have any rights anymore to abortion. So Texas may ultimately win, even if their little trick doesn't work. And I don't think it will work. I think Justice Kavanaugh and Justice Barrett seem very skeptical that we should allow this, as you say, anarchy. It can't be. Here's the other thing that I think a lot of people are concerned about is that journalists will see the Supreme Court striking down the tactics in SB 8, the trick that Texas used to insulate this from constitutional review, and then see them coming out the other way in Dobbs and say, it's kind of a compromise. It's kind of a moderate road. In one, they're going against Texas, and in one, they're not going in Texas. I can't stress how incorrect an assessment that is.
Why is that?
Because to hold that this unbelievable trick / subversion of constitutional rights mechanism is not permissible is the only possible holding. It is not a liberal holding. It is not a centrist. It's just, it means it's like, we're not saying it's the end of the Constitution. To then hold that Roe and Casey are no longer on the books is as far as radical as one can go. So if they come out, as I think they will, splitting on those two cases, I hope that journalists understand enough to know that is not a kind of centrist, moderate position on the part of this court. The annihilation of Casey and Roe is Armageddon for abortion rights.
And Dobbs would do that because it speaks of a 15-week viability standard as opposed to the established 24-week. Is that the essence of its radical nature?
Yeah, well, so there are two routes that the court could take in Dobbs. We have this 15-week ban. And the question presented in Dobbs was, is the viability, can the state ban abortion prior to viability? That's what Mississippi did with the 15-week ban. The slightly less radical approach would be to say, yes, states can ban pre-viability. Maybe 15 weeks is kind of the new line. Or maybe we're going to uphold Roe and Casey in name, but we're going to allow the state to ban at 15 weeks pre-viability, and we're going to allow a lot more regulation. But there still is somewhere at bottom a fundamental right to abortion. That seemed to be what Chief Justice Roberts would prefer, as it looks more moderate. It's not the full step of overruling Roe and Casey. It's just allowing the state to ban abortion earlier in pregnancy. I think functionally, it's pretty close to overruling Roe and Casey because it would just allow tons of state regulation, probably. But I will tell you, it didn't sound like Justice Kavanaugh or Justice Barrett was there with the chief. It sounded like you had a majority of justices for the overruling of Roe and Casey. So that would mean just saying there is no fundamental right at all. There is no line. And that is what I meant by Armageddon. I think Roe and Casey are gone. It just depends on how the court describes what it's doing. Maybe it'll just say it's overruling Roe and Casey, or maybe it'll say it's just allowing a lot more regulation, but there is still some possible right there. Maybe there is some limit still on what the state could do. That is another way that the decision could sound. I think either way, it's terrible for abortion rights, but the headlines might look a little different depending on which way the court goes. One
of them would be the Roberts putatively more moderate path, and the other would be sort of the more radical path. Can you illuminate us as to how you listened to the hearing this morning, the oral arguments? What did you hear? You told us a little bit about what you heard in terms of Kavanaugh and Barrett. What else did you pick up that prompts you to think that things might go in the way they will go?
Well, I think it's pretty clear that, it's undeniably clear that the most conservative justices are just ready to overrule Roe and Casey. They've said numerous times that they're ready to do that. They think those decisions were wrong. They were grievously and egregiously wrong. They don't think they're workable. They don't think people have relied on them. I think they just are ready to get rid of those. So everyone was kind of listening for the Chief Justice and Justice Amy Coney Barrett and Justice Kavanaugh, because they were the ones, there's some question about what they might do. So I was really listening to them. As I said, I think the Chief Justice sounded, as he often does, like he might want to take the ostensibly seemingly more moderate route. He wants to preserve the institutional fortitude of the court and the perception that they're not just political. And you can scale back enormously on abortion rights without formally overruling Roe and Casey, which will be a 24-point headline in the New York Times. Roe overruled. I think he thinks we don't need to do that. We can do it gradually. We can do it step by step. We can avoid that perception and any possible backlash. So what I was listening to is, are Kavanaugh and Barrett going to be with him? And nobody knows, but I will tell you, they were not asking the kinds of questions that would lead you to think that they were thinking along those lines. Justice Kavanaugh recited a long line of what he said were some of the greatest Supreme Court decisions in history. And he noted that all of them were overruling a past precedent. And so, he noted that everyone on the court has overruled precedents before, and overruling precedent is not a bad thing. And, that doesn't sound like someone who's trying to gear up to uphold Roe. He was laying a foundation for getting rid of it. And Justice Barrett was also speaking in those terms, as she was at one point, something that's gotten a lot of attention is at one point she was questioning whether there is even this fundamental right in the Constitution, because as we've established, it's not listed there. There's no right to abortion listed in the Constitution. And she was saying that her argument was Roe and Casey focused a lot on the burdens of parenthood. For 18 years, you have obligations. It's expensive. It's time consuming. Right? The undertaking of parenthood is one of the most substantial undertakings people undergo. And she was saying, that's what those decisions talked about. We now have what are called safe haven laws in every state, where you can drop your baby off at a firehouse if you don't want to take care of it, and your parental rights will be terminated. You can put it up for adoption. So her argument was all that burden is not really on women anymore. They can just have the baby and then give it up for adoption. And she was kind of suggesting this was changed facts on the ground. And then the state's advocate jumped on this and said, oh yeah, Texas enacted the first of these laws in 1999. So things have changed. Now you can put your baby at a firehouse, so you don't have the same burdens. I think this is a terrible argument, but that doesn't sound like someone who's trying to uphold Roe and Casey. Sound like someone who's quite skeptical that there really is a constitutional right to abortion, or that the burden really is so great, or in a way that could outweigh the state's interest in protecting fetal life.
What's so interesting and counterintuitive and ironic is that this shift in legal reasoning and political activity has occurred while still a strong majority of Americans support a woman's right to abortion. How do you explain that dissonance? As someone who studies the way in which legal reasoning takes form and legal decisions are made, to be sure, there's no direct correlation between popular sentiment and a legal decision, but it's the dissonance here is very striking.
It is, and it's really interesting. So I'll say just about this particular case, this is just true, empirically true from a political science perspective, that the justices are very far to the right of the American people right now. The pendulum has swung considerably. So they are out of step with where Americans are. This may be because, one contributing factor is a lot of them had been appointed by presidents who didn't actually win the popular vote. But one thing that's so fascinating to me is that political scientists have always said that actually the Supreme Court doesn't get too far out of step with the American people. It's kind of like a pendulum, which always returns to the middle, because what happens is if they get too far out of step in either direction, then there's an election where the American people elect someone on the other side. And then that new president appoints justices that bring the court back to the middle, and that keeps happening. If you look throughout American history, one thing that's interesting is the court often has been where the median American is. It often tracks politics, and it's because of the appointment process that the president is popularly elected. The president appoints the justices and keeps the court kind of in line. What's so interesting to me is that these theorists were working in the 50s and the 60s when justices were dying at earlier ages, and the judges were getting appointed much more quickly. These days, people are healthy, and especially Republican presidents have decided to appoint very young justices. This is brilliant because you can get someone on the court for 60, 50 years. Judges are some of the most long-lived people, and they can stay into their 90s. And so if you appoint a 40-year-old, right? No Republican is going to appoint a 60-year-old to the bench. It's just not going to happen. They're going to appoint Amy Coney Barrett to the bench so she can be on there. And anyway, the point is that this has enabled the Supreme Court to get out of step with the American people because the justices aren't turning over at the same rate that they used to. And so they're not replacing themselves. And that's one explanation for why the court's so far to the right. It's also true that the Republican Party has made organizing around judges really central to, that's one of the most important things. National officials run on that, and they've made it a priority in a way that Democrats haven't. So they have gotten a lot of judges on the court. So that's where we are. And as I said, it's not just the Supreme Court, it's all the federal courts. So I think we're going to be here for a while.
So you've helped us understand how we got where we are. And you've explained with real texture the moment we stand in now. As a final question, I'd like to ask you what you think the post-Dobbs world looks like, a world in which you have justices built to last for a generation, judges and justices built to last for a generation, in which we're perhaps unlikely to see any reversal of the decisions made by the current Supreme Court. What does it look like, particularly for women, women's right to privacy and bodily autonomy?
I don't think it looks so good. I think the Guttmacher Institute, which is kind of the gold standard for abortion policy, has a chart up showing that there are 26 states that will certainly or extremely likely ban abortion immediately after Dobbs comes down, if it gets rid of Roe and Casey. So more than half of the states, and I think that was about 40 million women of childbearing age, will immediately have no access to abortion in their states. We'll have to see what happens with the other states. I think there'll be a dozen or more states that will strengthen abortion rights. I think, California and New York and Massachusetts will become the places that people have to get to if they have the money. So I think wealthy women will still be able to get abortions in America as they always have. And there was a lot of briefing on this in the case. The consequences for poor women, for women of color, and for rural women are going to be absolutely devastating. Absolutely devastating. We're going to return to a situation where people don't have any access, and that doesn't lead to good health outcomes. It doesn't lead to good results for those women. It doesn't lead to good results for their other children. Most women who have abortion already have children. It is incredibly, I think, a dire situation. And I think that's what we're headed into. The question is, so that unfortunately, I think, is just the reality of what it's going to look like. that if you have the money and the resources, it'll still be available in some states, but in a lot of states, it's just not going to be available. But the big question is, will there be a lot of mobilization and organizing now to make this a priority for those who support the right to abortion, which, as you say, is the majority of people? Because one thing that's very important to keep in mind is when the Supreme Court guts or overrules Roe and Casey, it's not banning abortion. It's just saying that the Constitution doesn't protect the right. So we need to go out, whatever side you're on, you need to turn to your legislature. You need to campaign and you need to lobby. And if you believe that women need to have a right to abortion, you can pass laws enabling that to happen. The Supreme Court's not standing in the way of that, at least post Dobbs. So I think the situation will depend on how much mobilization, how much lawmaking, how much policy work gets done to try to make the legal systems of states more reflect the majority of the people's thinking.
And just one add-on to that. And what does the overturning of Roe portend for the law, the distribution of justice, and the legal norms and values that you study so carefully? Do you fear for an anarchic world in which sort of political sensibilities replace any measured assessment of justice in the law?
No, that's a big and interesting question. I mean, I think the court will take a hit even more to its popularity because the perception will be that it is just a political body. Some liberal scholars have said that's a silver lining. The court should take a hit. We shouldn't accord this institution so much power. As you probably know, there's been a ton of interest on the left in court reform, in either increasing the number of justices on the court or taking jurisdiction away from the court on certain. There are lots of levers and methods that that Biden can use and Congress can use to constrain the court. And I think there'll be added emphasis on those. But I think this court will continue apace. Thus far, it hasn't been really afraid of these court restricting measures, and I don't blame it. I think it's correctly reading the room. President Biden doesn't seem to be prioritizing that right now. If I were those justices, I would go ahead and do what I want. I do not think I would fear this Congress getting anything done to restrict my power. Maybe that could shift a little. Maybe that could change. My somewhat pessimistic view is we'll just kind of limp along. The court will take a hit, but it'll keep doing what it wants. And perhaps the American people will mobilize to protect rights and majority views. And I hope for democracy that they do.
Well, on that sobering note, I want to thank you, Professor Cary Franklin, for a most illuminating conversation. This has been really an important and challenging conversation. We thank you for making time out of your busy schedule.
Oh, thanks for having me. It's been fun.
Then thank you to our listeners. Please have a safe and healthy day.
Thank you for listening to Then and Now, a podcast by the UCLA Luskin Center for History and Policy. You can learn more about our work or share your thoughts with us at our website, luskincenter.history.ucla.edu. Our show is produced by David Myers and Maya Ferdman, with original music by Daniel Reichman. Special thanks to the UCLA History Department for its support, and thanks to you for listening.